Hey everybody, it's Mike Kennedy. Welcome back to the garage for another in the garage series CLEs that I've been doing during the coronavirus pandemic, staying at home, trying to get some content up there for folks who aren't able to get out and get CLE. You Vermont lawyers may have heard already, the MCLE board waived the 10-hour limit on self-study. These trust account CLEs count as self-study. I hope they are useful, not just to claim credit, but to give you a little bit more knowledge about trust accounting. Did one this morning that was relatively short, only 24 minutes long, on the basics of trust accounting. Not even really the basics, it's before the basics. The idea was to try to convince lawyers not to fear trust accounting because we avoid things that we fear. And trust accounting is not something that we should be avoiding. We have to be doing it. Otherwise, could face a licensing issue. Not to mention, could put client funds at risk. Back tonight, doing another one. Pretty quick turnaround. A couple things, couple updates. First, I hope everybody's doing okay. Staying safe, staying home, staying healthy. If you didn't hear me this morning, you lawyers who have questions about how to practice or not practice during the pandemic, check out my blog. A couple posts this week that share the things you should be doing and considering doing, and share examples of things not to do. Housekeeping. It's freezing cold out here, so I have my jacket on, my Run Vermont jacket, my Run Vermont hat. The hat is keeping me warm. It's also helping your eyes, it's keeping the glare from my bald head from reflecting into the screen. Behind me is the garage bar. The garage bar is not open because, as I always say, that would be inappropriate. I do have some coffee going. There's a pot of coffee I just made. It's over there on the bar. When I'm not here during the summer and I leave the garage door open, which I did today for some foolish reason, which is why it's so cold in here, I hang a flag over the bar so nobody can see all the bottles and come in and steal them. Because man, my neighborhood is rough. The flag I've got up today to try to change the background for folks is my No Shoes Nation flag. I'm a huge Kenny Chesney fan. So that I got the Kenny flag flying behind me. So yeah, I'm back quick, which is good, I think. I'm not a huge fan of trust accounting CLEs, as I mentioned this morning, but let's get right to it. So let me get the presentation up. And we shall start. So this is part two. Again, part one was this morning. Part two is the basics and trying to hammer home the idea, whatever you do, don't commingle. And we will talk about that a little bit later. This one's going to be a little bit longer than this morning. I know I said this morning that I'd keep them short, 15 to 20 minutes. This one didn't flow well, breaking it up. So I just went with the material that I had. I'm not sure how long it'll be. You can probably tell already by looking down at your screen to see how much time is left. And I'm just talking right now as I try to get the screen to advance. Okay, so here's what we're going to talk about today. 7 different things. Number 1, do I need a trust account? Actually get that question not infrequently. Number 2, if I need one, where can I open one? There's rules on that. Number 3, can I have more than one trust account? Number 4, when I open one, what do I have to tell the bank? Number 5, don't commingle. Number 6, I'm going to go through the record keeping requirements. And number 7, I'm going to talk about collected funds and when lawyers can and cannot disburse against certain deposits. But first, we are doing a pretest, a pop quiz. There are 8 questions, including a bonus question. I'm going to give you the questions, and then instead of giving you the answer, I'm going to go through the presentation. So you can change your answers as you go, and then I'll go through the answers at the end. But let's start with this pretest. First question, in Vermont, a lawyer licensed to practice law here must have a trust account if the lawyer holds funds of a client or a third person in connection with a representation, and the funds are what? Is it A, the funds are in the lawyer's possession as a result of a lawyer-client relationship? B, the funds are not reasonably expected to earn net interest and dividends for the client or third person? C, the funds are reasonably expected to earn net interest and dividends for the client or third person. Or D, this is a trick question. Oddly, the trust account rules make no mention of when a trust account is required. Now, I know this is sort of a wordy question and the options are wordy, but as I said this morning, the trust account rules are not well drafted, in my opinion. They are too long, too wordy, and you end up with things like this. But what is the rule? When do you have to have a trust account, or is it not in the rule? So again, is it when you're holding funds as a result of a lawyer-client relationship? Is it only when you're holding funds that are not reasonably expected to earn interest? Is it only when you're holding funds that are reasonably expected to earn interest, or is it a trick question? Give you a little bit moment on this one. All right, question 2. To be on the professional responsibility programs list of approved financial institutions, those are the banks where you're allowed to hold trust accounts. What must that institution not do? Is it A, the institution must not be a credit union? Is it B, the institution must agree to insure a trust account for no less than $500,000? Is it C, the institution must agree to notify disciplinary counsel whenever a check drawn on a trust account is presented against insufficient funds? Or is it D, all of the above? So by rule of the Supreme Court, there's one thing, or maybe there are 3 things, that's the question, that banks must comply with in order to be on the list of banks that we approve to hold attorney trust accounts. Question 3. Is this true or false? The Vermont Rules of Professional Conduct allow lawyers to pool funds from multiple clients into a single trust account. True or false? Warming up a little bit. Can't wait for summer. Get the garage door open and do some of these with my grill going. Maybe we'll have the technology. You'll be able to smell what I'm grilling. Question 4. By rule, when opening an IOLTA, a lawyer must inform the bank that the interest on the account is to be paid to what? Is it A, the Vermont Bar Association's Client Security Fund? Is it B, the Vermont Supreme Court's Attorney Licensing Fund? Is it C, the Vermont Bar Foundation? Or is it D, the lawyer gets to choose between the 3 as to where the interest on the IOLTAs will go? Question 5. By rule, how long must a lawyer keep records of funds held in trust? Is it A, 6 years after the termination of the representation? B, the rule suggests 2 years but leaves it to the attorney's discretion? Is it C, the rule suggests 2 years, but I caution lawyers to remember that disciplinary counsel's compliance audits usually go back for 3 years? Or is it D, the rule is silent? One of these days, the rule is silent is going to be the answer. Is it today? I don't know. Find out later. Question 6. Which is one of the minimum required features of a trust accounting system in Vermont? Is it A, the system must include records showing receipts and disbursements from the account? Is it B, the system must include records showing receipts and disbursements made for each client? Is it C, a single source identifying all trust accounts maintained by the lawyer or firm? Or is it D, all the above? You know, all of the above is how it used to be on the tests I would take in school. When you spell check it and do the grammar review, it takes out the word of. All the above. Maybe that's the answer. Question 7. By rule, how often must a lawyer or firm reconcile a trust account? You know, if you follow the 5 for Friday quiz, I mentioned the question this morning that I've asked in like half the quizzes. I've done 197. I think I've asked this one in the other half. Is it A, timely, with timely defined as no less than monthly? Is it B, quarterly? Is it C, as recommended by general accounting standards and best practices? Or is it D, the rules are silent, but there's case law that says, quote, more than 2 months without reconciliation is a violation of the general duty to safeguard client funds. So what's the rule on reconciliation in Vermont, or what's the state of the law on reconciliation in Vermont? Question 8. By rule, a lawyer shall not disburse funds from trust unless the funds are collected funds. Now that's a true statement. What I want to know is true or false. There are no exceptions. True or false. Cannot disperse until you have collected funds. And there's actually a bonus question, very, very loosely related to trust accounts. So the attorney, the person in the picture, that's Kim Wexler. Kim Wexler is a TV attorney who represents the Mesa Verde Bank and Trust. Get it? Bank and Trust. Which is a financial institution regulated by, hint, the state of New Mexico. Kim's law partner and romantic interest is Jimmy. They joined together to form a firm that goes by the name WM. W is Wexler. Jimmy doesn't exactly model ethical behavior. Not in this show, not in another show in which he practices under a different name. In a way, the answer to this question, what is the TV show that you find Kim Wexler in, is a prequel to a sequel. Name the TV show. Okay, I guess the fun's over. Now we got to get down to trust accounting. So back to the basics. Let's start with, do I need a trust account? Here's the rule in Vermont. If funds that belong to a client or third person are in a lawyer's possession as a result of a representation in a lawyer-client relationship, the funds must be deposited into a trust account. That's the actual rule as it's written. Again, I think it's a little maybe redundant or wordy, but basically if you're representing a client and you're holding funds that belong to the client or a third person in connection with that representation, they have to go into an account that's labeled trust account. So lawyers often say, do I need one as soon as I start practicing here? Whether they're brand new admitted to the bar, I'm not sure I said that right, or brand new to Vermont from a different state. Well, you don't need one right away, but as soon as you handle funds in connection with a representation that belong to a client or third person, you got to have somewhere to put them. Your desk isn't good enough. They got to go into a trust account. So if you expect to be handling funds, I would open a trust account before you even receive funds. Where do I open a trust account, Mike? Well, the approved financial institutions that are on the list on our website, the link is there. It's the Vermont Judiciary website. You go there, click to Supreme Court, click to the courts boards. You'll see the PRB. Under the PRB, you'll see trust accounts, and scroll down. The short answer is there are not many, if any, banks in Vermont that are not on the list. But if you're concerned, check it out. That's where it is. So remember, there are two types of trust accounts. There are pooled interest-bearing trust accounts, and then there are trust accounts that bear interest for the client. In the former, the pooled interest-bearing trust account, that's what we all call IOLTA. The rules never use the phrase IOLTA. The rules refer to pooled interest-bearing trust accounts. How do you decide? You say you're representing me, and I give you money to hold in connection with the representation, and it's in your possession because of the lawyer-client relationship you have with me. Does it go into an IOLTA, a pooled interest-bearing trust account, or does it go into a trust account labeled as such, but one to which the interest goes to me? The default is to the IOLTA. And basically the definition in the rule is, if the funds I give to you that you're going to be holding in connection with the representation of me are not reasonably expected to earn net interest or dividends as defined by the rule, they go into an IOLTA. The rules, again, it's a little complicated. It does make clear though, that if you're on the fence, I'm not sure if these should go into an account where Mike gets the interest, or I'm not sure if they should go into the pooled interest bearing account where the interest goes to somebody else. I'm not going to say who because that's one of the quiz questions and I'll get to that in a minute. Anyway, that's the default. The rules say if you put it into the IOLTA, and even if you're wrong, probably should have gone into an account where the interest went to me, you can't get prosecuted for it. It's very, very rare that a lawyer is holding funds that do not go into the IOLTA. Give me a call if you have questions, but that's the analysis there. Can I have more than one trust account? Yes, you can. You're not required to, but you can. Some of you who practice real estate law know that many of the banks, the lenders, want you to have an account there to close on their loans. That's fine. One tip, if you have more than one trust account, especially if they're at different banks, I would figure out a way to separate your checks. So you're never confused about which account you're dispersing from. That has happened often. You know, we do get notified of overdrafts to an account, and it is not at all uncommon for the lawyer's explanation of the overdraft to be, oh, it was the blah blah bank account that I wrote from by mistake. I meant to write from the da 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 bank. I grabbed the wrong checkbook. I was working too quick. Technically a violation, so be careful. I mean, we're pretty reasonable. Sarah Katz is pretty reasonable when she investigates those overdrafts, but be careful. So yes, you can have more than one. Don't commingle. You know, I talked about this in the seminar this morning. The rule says keep your money separate from money held for clients or third persons. This is not a new concept. Lawyers seem troubled by it, often have lots of questions about it, not new. Again, mentioned this morning. In 1836, an attorney named Douglas Hoffman wrote what are considered to be the first set of rules to apply to the legal profession. His rules were resolutions, 50 of them, that he resolved to make every year. I've written often about them. It's interesting to me, as sort of a legal ethics nerd, how many of his 50 original rules show up in the rules that govern the profession today. Here are the blogs posts I've done on it. I won't go through them all, but basically he resolved to do certain things. Treat people, I guess I will go through them all. Treat others with civility, avoid conflicts of interest, return the file when the representation ends, provide his clients with diligent representation, communicate with his clients candidly, giving them reasonable expectations about what's going on and what will go on. And he also resolved to mentor newer attorneys. All of those things that he resolved show up in today's rules. He also resolved this. His resolution, the 26th that he made of the 50, is on the right. On the left is our current rule, 1.15, paragraph A. I think they're almost exactly the same. Here's what he resolved in 1836. I will on no occasion blend with my own my client's money. If kept distinctly as his, it will be less liable to be considered as my own. Switch it over. Our current rule, a lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with the representation, separate from the lawyer's own property. Separate means not blended. Same thing. So commingling and the prohibition against it is not a new concept. I try to tell lawyers this. Here's why we don't commingle. A couple reasons. We got to keep the trust in trust accounting. Trust accounts are not our accounts. That's why we don't commingle. Some people say, well, Mike, why is it such a big deal? And who says it's such a big deal? Just because that guy Hoffman wrote it in 1836? I'll tell you why it's a big deal, and I'll tell you who says it's a big deal. The Vermont Supreme Court says it's a big deal. Here's what happened. 2008, pretty benign facts. A lawyer was picked for one of the random audits that we do. The audit revealed that the lawyer's bookkeeper had regularly taken $200, I think it was a week, $200 a week from the operating account, deposited it into the trust account, No ill intent, the only intent being to make sure that the money was there at the end of the month to pay expenses, because the lawyer had trouble, wasn't loose with client money, wasn't great with lawyer's own money. Bookkeeper wanted to make sure the bills got paid, so it was sort of a forced savings plan. There was no evidence of ill intent, no evidence that the lawyer ever took even a single penny from the client. The lawyer had been practicing for more than 25 years with no prior discipline. A hearing panel heard the case, recommended an admonition, which is a sanction that doesn't identify the lawyer. The court, our Vermont Supreme Court, took it up on its own review. So if you don't know, the hearing panels are the PRB's version of a trial court. After they issue decisions, either disciplinary counsel can appeal, the lawyer who got prosecuted and sanctioned can appeal, and even if neither appeals, the court can order review on its own motion. And that's what it did in this case. Now remember, under our rules, admonitions, a sanction that doesn't identify the lawyer, they are only appropriate in cases of quote unquote minor misconduct. So I just described to you those really benign facts, and what the hearing panel says was, that's pretty minor, this is minor misconduct. Supreme Court said, oh, no, no, no. As we have explained in the past, protecting client property is a fundamental principle. Commingling personal property with client property is a serious offense because of the likely negative consequences that may result to an attorney's clients. The court went on, as another court has explained, quote, the rule against commingling has three principal objectives: to preserve the identity of client funds, to eliminate the risk that client funds might be taken by the attorney's creditors, and most importantly, to prevent lawyers from misusing, misappropriating client funds, whether intentionally or inadvertently. So in the end, the upshot was, it's not minor misconduct to commingle. The mere fact of commingling is more than minor misconduct. It's that simple. Therefore, public reprimand. The fact that the lawyer had all the other things going for the lawyer, you know, the no record of discipline, long history in the practice without that discipline, no bad motive, bookkeeper was just trying to make sure there was money left over to pay the bills, that mitigated against something more serious than a public reprimand. Still a public reprimand though. I'm not citing the case because there's no need to. I just want to make it clear that our court has said commingling is a serious violation of the rules. Of course, there's the exception that it's in Rule 1.15b. A lawyer or firm may deposit the lawyer or firm's own funds into trust, but remember, it's no more than is necessary for the sole purpose of paying service charges or fees on the account. Our hearing panels have strictly interpreted that. You can't just dump money in there willy-nilly or guess how much in service charges and fees are going to accrue on your account. The amount you put in has to be tied to those fees. If it's not, you could get sanctioned. In fact, lawyers have been sanctioned for that. Okay, moving on. Let me just back up. Why are lawyers sanctioned? How do we find out? Usually we find out, I think almost all the time we found out. I have to look though. There are 6 or 7 cases, I cited it in my blog, where lawyers are just picked for the random audits. You know, Sarah's office does, I don't remember how many per year she does, maybe 10 to 15. And the auditors are good. They're competent accountants, CPAs. They know what they're doing. And they know what to look for. And they see, you've got more money in here than is needed to pay for the costs that your accounts are incurring. So that's how we find out about those. Okay, so moving on. We know when you have to have an account. We know where the accounts have to be. We know you can't put your own money into your trust accounts. What else do you have to have? Well, there are certain record-keeping requirements, a trust accounting system that you have to have. And those are spelled out in Rule 1.15 capital A. At a minimum, your trust accounting system must include records that show the source of each receipt and the nature of each disbursement, including the amounts, into the pooled interest-bearing trust account or into my personal, the one you're maintaining for me. But let's focus now on pooled interest-bearing trust accounts, the IOLTAs. Anytime money goes in, no matter who it's for, there's got to be a record that shows it went in and who it came from. Whenever money goes out, there's got to be a record that shows why it went out and on behalf of who did it go out. Same for each client, so sub-accounts. So there's the pooled interest-bearing trust account where you've got not just my money, but money that belongs to all the other clients you're representing. We each have to have our own individual ledgers too. That does the same thing for us that the ledger for the, the pooled interest-bearing account does. Your system has to show that you give timely notice to clients of receipts made on their behalf and disbursements made for them. Reconciliation, no less than monthly. There has to be a record of that. And you need a single source that identifies all the trust accounts that you maintain. What's important to remember here, those are just minimum requirements. You can have more. Your checkbook isn't good enough. And how do we know that? Well, here's how we know. Way back when I was a prosecutor, a lawyer, an overdraft notice came in. Do what we always do. Dear lawyer, the bank has notified us that your trust account is overdrawn. Please explain. You have 5 days. The lawyer wrote back, thought I had it in my check register. Sorry, just sort of messed up. Followed up. What do you mean you thought you had it in your check register? Oh, I used my check register to keep track of my account. Sort of got lost that month, missed something. Literally, the lawyer's only record keeping system was, those little pages at the back of a checkbook. That does not count. That does not meet the minimum requirements of a trust accounting system under our rules. The lawyer was publicly reprimanded. There are so many systems available nowadays, online that make it not easy, but they're easily available. If you don't know how to do it, a lot of sole practitioners and small firms, get a bookkeeper. It's well worth the expense, I think, especially if you're audited, to avoid a sanction. Sloppy bookkeeping, you never know. That could result in a sanction, even though it's just a mistake, because the hearing panels and the court, again, have to harp on this, have made it very, very clear that we are going to interpret the trust accounting rules strictly. We're not going to just start cutting people breaks, and we shouldn't, because it's other people's money. Keep the trust in trust accounting. Finally, on record keeping requirements, you have to maintain records of funds that were held in trust for clients or third persons for 6 years following the termination of the representation. That's the rule. Yes, usually it is true. I referenced it in the question. The auditors, when they go in, typically only go back 3 years to start. The rule would allow them to go back 6. And if you don't have those records, that's a violation of that rule. Even if there's nothing wrong, just not having the records is a violation of the rule. Okay, moving on. Collected funds. Here's the rule, Rule 1.15F. And it's relatively new. I'll tell you a story about that. Lawyer shall not disburse absent collected funds. And the rule defines collected funds as funds that a lawyer reasonably believes have been deposited, finally settled, and credited to the lawyer's account. If you look at the reporter's note to the amendment we did in 2005, it suggests that if a check or instrument is from a bank in the same Federal Reserve district as we are, probably good in 3 days. If it's from a different Federal Reserve district or region, whatever they call them, probably not good for 7 days, business days. So that's generally what the rules suggest it takes for checks to clear. That may have changed, given that that was 15 years ago now, and we're doing even more electronic banking than we used to, but it may not have changed. I don't know, haven't looked. Anyway, why is this such an important rule? Not to disburse without collected funds. Give you time to think. When you disburse without collected funds, what are you doing? Besides taking a risk? Well, here's the answer. You are using my money to carry out somebody else's business. And we have a rule. It's Rule 1.15F, paragraph 2. Should have had my book open. I didn't. But here's what the rule says. It says, a lawyer shall not I'm getting there. A lawyer shall not use, endanger, or encumber money held in trust for a client or third purpose for the purpose of carrying out the business of another client. So, you know, if you are representing me and you're also representing my brother, and my money is in trust, and he gives you a check, and you write against it on deposit, and his check that he gave you is no good. No offense, bro. Sorry, just using this as an example. You write against it on deposit before his check constitutes collected funds. That check is cashed. My money is used to cover that check. What if you never get the money back from my brother? My money's gone. You're going to have to make good on that, and you might get sanctioned. So that's why it's an important rule. Now, there it is. Can't borrow from Michael to pay for Patrick. Now, I've just told you why it's so important and that we strictly interpret these trust accounting rules. So are there any exceptions to the rule on collected funds? Some of you practice in an area of law where you're like, wait a minute, if I have to wait to have collected funds before I disperse against a deposit, I've been violating the rules every single time I do blank. And this is why the answer to the question, are there any exceptions, is yes, there are. So here's what happened. Back in 2004 or 2005, somebody, I don't know who, asked the VBA's Professional Responsibility Committee for an advisory ethics opinion on when can you, there were several questions, like 10 of them. One of them was, when can you disperse against a deposit? And the committee correctly, in my opinion, interpreted the rule as it was written then as being very clear. You cannot disperse until you have collected funds. That raised concern, especially among the real estate bar. As anybody who's ever bought or sold a home knows, when you do them back to back, you know, I sell my place, I get the check from the buyer, give it to my lawyer who deposits it, you know, and 45 minutes later, I'm buying another place using that money. And the lawyer is writing against a check from my buyer that does not yet constitute collected funds. So when the committee issued that opinion saying can't do that, the real estate bar worried. So we changed the rule. We put in an exception that says there are certain instruments that we will consider to constitute collected funds on deposit. They're so unlikely to fail that it's reasonable to consider them as constituting collected funds as soon as a lawyer deposits them into trust. They are listed in Rule 1.15G. The first exception is, you know, all the different types of instruments that a bank issues, like a certified check, a cashier's check, blah, 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 blah. We also include an exception for checks drawn on a lawyer's trust account, as long as the lawyer is licensed in Vermont. That also helps at real estate closings when, say, the lawyer's holding the deposit, or IORTA accounts, which are real estate agents' trust account checks. You can write against those on deposit as well. You can also treat as constituting good funds checks issued by the United States of America or the state of Vermont. Also, checks issued by insurance companies, including title insurance companies that are licensed to do business in Vermont, and personal checks, but only up to $1,000 in aggregate for the whole transaction. So if a client gives you a check for $900, you can write against it on deposit before it clears and constitutes collected funds. But if a client gives you a check for $1,400 and then somebody else is giving you a personal check for a little bit more, you got to wait for those checks to clear before you can write against them. So those are the exceptions we put into the rule on collected funds. Now remember, they're exceptions, they're not the rule. So I get this question often in ethics inquiries from lawyers, usually in the context of settling some sort of civil claim where the person wants their money. And the lawyer doesn't want to have to pay it right away, not because the lawyer doesn't want the money going to the client, but because the lawyer wants to make sure there are good funds in the account before the lawyer writes against the deposit, especially in this day and age of scams. I think that makes perfect sense for lawyers to be cautious. So just because we've said you can write against certain instruments, For instance, the settlement check from the insurance company does not mean that you have to. You still can wait for the funds to constitute collected funds. Now, there's a line somewhere where when you wait too long, that's a problem. Because remember, as we mentioned this morning, there is a rule that says a lawyer must promptly disperse funds that belong to somebody else. But you can wait until the, probably the 3 days to 7 days that we talked about earlier, just to make sure the funds are good. There's no problem with that. I've told lawyers, hey, if your client is upset, have your client call me. I'll take the blame by telling them what the rule is. And I've done that. Okay, so what if one of the instruments that fall on the list of exceptions, meaning you can write against it on deposit, so you do, and then the instrument fails? We were wrong. Generally, they're never going to fail, but in this case, one failed. Well, the rule says you have to take immediate steps to protect funds of other clients that are still in trust or perhaps are gone. The reporter's note to that amendment says when that happens, those immediate steps you take to protect other clients, quote, presumably by immediately making or securing reimbursement of the trust account to the amount of the failed deposit. I interpret that as meaning this is another sort of exception to the rule against commingling, because it's not really commingling. You're putting in money that you lost. You took the risk by writing before the instrument cleared, even though we said it's okay. You're not going to face a disciplinary sanction, but you still are on a financial hook for the money that's gone. Okay. Now let's go through the answers. And I think that probably, this is the point where I'm looking out there and lawyers are saying, oh my gosh, I don't want to practice law anymore. Or I'm hiring an accountant. Do the latter, don't do the former. So here are the answers. I think I addressed most of them in the discussion. Question 1, funds go in trust if they're in your possession as a result of a lawyer-client relationship. Doesn't matter whether or not they're going to earn interest. They still have to go into a trust account. Whether or not they're going to earn interest for the client or to somebody else, I'm not going to say that yet, doesn't mean they're not in a trust account that still has to comply with all the trust accounting rules. Question 2, the banks, to get on that approved list, the only thing they have to do is notify disciplinary counsel whenever a check's presented against insufficient funds. If somebody tells you that the credit unions are not allowed to hold trust accounts, they're wrong. That came up a couple years ago. There was some concern because basically there was concern that FDIC insurance did not cover funds held in a credit union, and that some, I don't want to get into the weeds, but it's not true. We allow credit unions to hold trust accounts. Just like any other institution, they have to notify disciplinary counsel whenever a check's drawn against insufficient funds. Question 3, it's true. Talked about it, pooled interest-bearing trust accounts. Yes, with multiple clients, for each client, the money's not expected to earn net interest or dividends. They can go into a pooled interest-bearing account where the entire interest, when it adds up, goes off to somebody else. Still not going to say who. But now I will. It's the Vermont Bar Foundation. That's in Rule 1.15 capital B. The rule sets out what the Bar Foundation can use the money for, and essentially, I don't want to look through it because I'll be wasting your time. Actually, I will look through. Basically, it's to fund legal services for those who otherwise can't afford them, access to justice type issues. Question 5, you have to maintain records for at least 6 years. I mentioned that earlier. Again, it's a good idea to keep them for 6. That's the rule. So I'm not sure what I was going to say. It's a good idea. 6 years is the rule. They're all required by the rule that sets out what your trust accounting system has to include. The other thing that it has to include, we mentioned them earlier, reconciliation and timely notice to clients showing receipts and disbursements made on their behalf. Question 7. Timely reconciliation. Timely is defined as no less than monthly. That's actually only about 7 or 8 years old. D used to be the answer, where we didn't have a reconciliation requirement in the rules. We prosecuted a lawyer who had gone longer than 2 months. Both the hearing panel and the court said, we don't know when is too long, but longer than 2 months is too long. After that, we changed the rule to get it defined as you have to reconcile at least monthly. False. We just went through the exceptions to the rule on collected funds. Remember, you don't have to. You can, but you don't have to. And the bonus question, I'm not sure why it says question 5. The TV show that attorney Kim Wexler is on, where she represents Mesa, Verity Bank and Trust. Her partner in romantic interest is Jimmy. Jimmy's last name is M, begins with M. He's not very ethical. That's Jimmy McGill, who is otherwise known as Saul Goodman from Better Call Saul. So that gets me to the final segment today. You know, I've started this morning, the pop culture icon of the segment. Today I'm going with attorney Kim Wexler. Excuse me, not just because I used her in that question, but because I found out something pretty cool. So I've mentioned many times Professor Bernabe. He is a professor at University of Illinois at Chicago John Marshall School of Law. I think that's what it's called now. I spoke to his class yesterday. He has a great blog, the bernabepr.blogspot.com. Today he posted a cool post where Kim Wexler, in character, has a YouTube channel that she's using to put up videos that are like ethics presentations. So check it out. She's the pop culture icon of this segment, and thank you, Professor, for the tip. Anyway, that's a CLE and trust accounting for you. Hope it was helpful. Call or email if you want me to send you the PowerPoint. And I guess that's all. Thanks all for being here, and we'll see you next time. Take care. No Shoes Nation.